Good morning, everybody. This is Kevin Meaders here in Atlanta, Georgia at Magellan Planning Group, and I hope everyone can now start joining. So I see participants are already coming on board. That's great. Great. We got people from Texas, Oklahoma. Hey, there's Kentucky. Good to see you, Kentucky. West Virginia and Virginia. Wow. Oregon. I see Illinois there. California, Colorado, there you are. How are things out there in Colorado? Beautiful, I bet. Oklahoma, wow. Tennessee, great. Great to see everybody. We're going to go ahead and get started here. Just got a couple of things to follow. Housekeeping. So your RLT, what is RLT? Well, that means Revocable Living Trust, and we've done literally thousands of these over the last 30 years that we've been here. And I think Lynn probably did another few thousand before I even met him, because he's been practicing law since the 70s. But Revocable Living Trust is something that we've been using a lot over the last 30 years, like I say, and we've seen it at the front end, we've seen it at the back end, we've seen it all the way through, and pretty much every single consequence that you can imagine. So I feel very, very confident talking about that. Many of you have those. A few disclosures that we need to remember. This is not going to be tax advice. I can't give any personal tax advice. I can entertain some hypotheticals like we do in law school, but it's not tax advice, not legal advice. Remember all that stuff. And we're involved with Cetera to manage people's money. So Cetera has nothing to do with any of that. And if you have some questions, we always encourage questions. We had a workshop yesterday downstairs, and it was pretty full, and we had a lot of questions. So, you know, I'm sorry that I couldn't see you in person, but I'm happy to see you here today. And what is it? St. Patrick's Day today, so I've got my green on. And remember, St. Kevin is also an Irish saint, so it doesn't always have to be St. Patrick. It could be St. Kevin. So I'm gonna go with that. Questions are welcome, but you know, there's a chat box or some questions, a Q&A at the bottom of your screen. I hope that would pop up for you, and then just enter it there. I'm going to have to wait till the very end to ask questions, so I'll wrap up and then at the very end answer any questions that you might have. So just pop those in there, and we'll get to those at the very end. Thank you. So what we're going to talk about today is my good buddy Merv Griffin. You guys remember him. Kind of a genius in a lot of ways. What he did, he invented a lot of game shows that are still out there today. But you know, what we're talking about here is some pretty serious stuff, not too fun, really. It's life, end of life kind of thing. But as I tell everyone, it doesn't matter how much money you have, how much money you don't have. If you're alive today, you have a body, you know, and you have a mind. And sometimes our mind goes and sometimes our body goes. And sometimes that can be worse than even death. So one of the things that's a pretty heavy topic is, you know, that incapacity topic. And so, you know, you remember the the Terry Schiavo incident, and you know, this is one of the things we want to try to do is to avoid anything, especially that dramatic. But when we have incapacity and we don't have documents in place, we have a sort of a two-part process. And that process is, number one, and this is in Georgia mainly, and I think most states are somewhat similar, but for certainly in Georgia, you know, we have a step one, which is a competency hearing. Now, the competency hearing is a public hearing. So you know, anybody can walk in, I guess the press could too. And then usually we're going to have a lot of doctors and lawyers in this meeting, because the doctors need to testify that, you know, that grandma's incompetent or incapacitated mentally or physically and mentally. And then of course the lawyers, you know, are arguing that case, and the judge may appoint a guardian ad litem, which is an additional expense. So anytime you have doctors and lawyers in the same room, it's never good. Okay, and I would suggest that even if you have just doctors or lawyers in the room, it's not always good. So once we get past the competency hearing, and yes, okay, we've determined that grandma is incapacitated or incompetent, mentally. Then we proceed then on to the conservatorship hearing. And the conservatorship hearing is, well, we have to then appoint a conservator, and who is going to be in charge of grandma's money, who's going to pay her bills, who's going to take care of those things, who's going to pay her taxes and sign her tax return. So that's what the conservatorship hearing is, appointing that person. And then that person's just not off on their own. I mean, they've got responsibilities. They've got to file reports. Sometimes they have to post a bond. And usually they do have to post a bond, unless it's a guardian ad litem. That could also be the case where the judge appoints a lawyer that, you know, he or she knows in the county. I have a good friend that started his business that way and out in law, and now he's a probate judge. So, you know, he initially started out doing guardian ad litem stuff. And you can see some very crazy things in that category. So in order to get around the Terry Schiavo issue, what we want to have are living documents. Now, living documents, again, I'm not talking about even assets here. I'm just talking about your body, your life, your brain. You know, we have something called a durable financial power of attorney. Now, this allows you to appoint someone to handle the financial things for in your life. You know, even though you may not be qualified to do those things. So that's where the word durable comes in. If you are used to powers of attorney, you know that the principal, if the principal becomes incapacitated, that power normally ceases. But the durable power of attorney gives it the staying power, if you will, to endure past that incapacity of the principal. And that's important because that's why you need it, right? And in Georgia, at least, third parties such as banks are not required to accept them or honor them. So you want to go to each one of those banks or institutions that you have and make sure that they're going to accept the power of attorney that you have. Go ahead and do that, because they're also state specific. Now, Georgia recently has made a change to the financial power of attorney. At least in Georgia, they have a universal type of power of attorney that all the banks and all the power brokerage houses have to honor. So everybody in Georgia has to honor the statutory financial power of attorney. I think that's a fantastic idea, and I really applaud Georgia for doing that. And I hope more states will do that, because it's a gray area. You know, you don't know if your power of attorney is going to work or not. So once you get your power of attorney, take it to your institutions. I'm talking to people in other states. Take it to your institutions and make sure they will check that and make sure it works. Because again, not everybody takes it, and there's different for every state. And the key is that they're effective after incapacity, but you just want to make sure that all of your all the places that you have money or assets will accept it. Now, the thing that some people forget, at least, is that once the principal dies, that power of attorney is no longer any good. It doesn't function. So to go on using it is a crime. So you don't want to do that. Generally, what happens after the power of attorney, remember that the power of attorney takes care of us up to the point of death. And then after the point of death, now we're on to the successor trustee or the executrix. So all the power attorney, all the powers of attorney cease upon death, right? And then all of a sudden now we're on to the successor people, the executors, the trustees behind that. So that's the financial power of attorney, durable. Also, you have a healthcare power of attorney, also durable, because remember, if these don't survive your incapacity, then what good are they, right? So that's the important thing. The durable healthcare power of attorney is like the financial power of attorney. You're giving someone the power to make decisions on your behalf for you, but instead of it being finances, it's healthcare decisions. You know, do I need a kidney removed, or do I need this replacement? Do I need this dialysis? You know, am I going to wake up from this coma in 20 years? I don't know. So that usually is a child, or, you know, usually for me, it's my wife. It's usually your spouse initially. And then after that, your children or other family members, however it may be. And in my world, you know, or anybody's world, really, you can have your financial power of attorney and your healthcare power of attorney be two different people. So you might have one child that's very good in finances, like me, and then you have another child that's very passionate and loving and caring, like my sister Dawn, right? So in my mom's world, I was the financial power attorney and Dawn was the healthcare power attorney, but it doesn't always have to be that way. So in addition, and this is the Terry Schiavo thing, remember, besides the power of attorney, we also have the living will. What are my final directions? Do we want to leave me plugged in forever, or do you want to unplug me and let me go on? I have my decision. It's personal for everybody. I mean, I personally don't want to be left plugged in, but if there's a, if there's a reasonable chance that I can come back and live the life I've loved, then, give it a shot, right? But don't leave me there plugged in forever, please. I wouldn't like that. So then, now we talk about, well, passing on, right? So now we've passed on, and let's say we don't have our documents in place. We don't have appropriate documents. So every state has their own rules about what we call intestate succession. So intestate just means you died without a will or a trust in that case. So every state is different. I know about Georgia. Georgia has a plan just like other state. Every state has its own plan. Some states it's commonsensical, some states it's not. Now I tell you, like in Georgia, for instance, husband and wife, I know just by talking to them, a husband and a wife, I mean, and they've got 5 kids. The husband dies, the wife has the assumption that she's going to inherit everything, right? But that's not the case. She'll get no less than 1/3 in Georgia, but 2/3 will be split by the other 5 kids. So in most of the people that I'm talking to that have children together want to leave everything there for the spouse and her care for the rest of her life, and then they want it to go on down to the children. So just because you think that your state has good intestate succession rules, you might want to check them, because I think they also surprise some people. So when we come down to making a plan, an estate plan, there's only 2 choices, right? There's the will-centered plan, which we're intentionally going through probate, and then there's the trust-centered plan, which we're intentionally trying to avoid probate. That doesn't mean probate's terrible, and in some states it's not terrible, but in some states it is bad. And I can't really say which states those are, but you may figure them out based on some discussions we're going to have in just a minute. So probate, what is probate? Well, it's a Latin word. It derives from Latin, and it means basically to prove. You're proving up that you are the executor. You're proving up that these are the correct assets. You're proving up that this is the correct will, that these are the intentions of the decedent. You're proving up that these are the beneficiaries that the decedent intended to leave his or her assets to. So that's what all that means. And of course, it's a court supervised, because you just can't have everybody out there doing that willy-nilly in the wild, wild west, right? So you have to have a court supervised transfer of assets. And the way that works basically is the person who has the will of the decedent brings that in. We take that to probate court. We fill out a bunch of forms. We pay a fee. We go down there and swear an oath. And then a few days later, or maybe a few weeks later, we get these letters in the mail that are called testamentary, letters testamentary. And that gives the executrix or the executor the power to do all these things. And so you send copies of that form, those letters, everywhere that you're trying to move assets. And that gives the executor the power to do that. So that's that magic paper that we get from the court. But in order to do all that, we have to file things with the court. We have to do the inventory. We've got to do an appraisal sometimes. Sometimes we get weird assets, some fine art. Recently, we had a 1958 Mercedes-Benz Gullwing SL. I mean, it's a couple $1 million there. So, they're just not going to take our word for that. We've got to get things like that appraised. Public notices, we've got to run a notice in the local legal organ, whatever that might be in each county. And, there's lawyers in there just looking through that stuff. So that's basically a notification of the creditors that, hey, this, there we go. We're back live. Okay, good. So that's part of the process is, these creditors' claims, are they valid? Sometimes you have to have a contest. Sometimes you have disgruntled heirs, or, some I've seen where nephews or nieces thought that they were owed something and come and dispute it. So I've seen a lot of family dynamics change once someone has died, especially if that person has money, and especially there's a lot of, heirs around that expect things. So, it's hard to manage expectations. I can tell you that. And then we got to pay the creditors and all the administrative costs. The lawyers have to be paid. The court has to be paid. Taxes have to be paid. And then after all that's done, after however long that takes, then we distribute those assets to the heirs, which is really all you cared about to begin with, right? I mean, I don't care about the creditors. I don't care about the taxes. I just want my people to get the money that I worked for. I'm sure Henry's different about that. He wants to make sure the IRS is paid. So here's some probate facts that are fun. Any asset that's owned by a decedent must be distributed through the probate court, no matter how small. Now, things like IRAs, life insurance, annuities, anything that has a beneficiary designation automatically bypasses probate. Okay, so I don't want you to think that every single thing does. 401k plans, anything that has a beneficiary designation goes directly to the beneficiary. Also, there are accounts like TOD and POD, transfer on death for securities accounts, payable on death for bank accounts. So that's another way to bypass probate, but it opens up other issues in terms of the total estate and what you're trying to do. So not everything is foolproof, and everything usually has a give and take. There are positives and negatives to everything. The time the probate takes is usually 6 months initially, because we have to run those ads and run the notices in the paper and file things and go down and take an oath. And sometimes, especially during the pandemic, it was taking a couple of months to get the letters testamentary in. I think in one case, it took us 3 months to get their letters testamentaries. And then one good thing, though, is we were able to do the oaths through the Zoom process. And for now, they're still doing that. But now that's just Georgia. I don't know what your state is like, so that's why you want to check into it. Okay, it's also public record. I mean, anybody could walk into, whatever county Elvis died in. I think somebody said Shelby, I'm not sure, but walk in there and check out Elvis's will, see, what he had, where it went, who got what. You could do that anywhere, and that's public record all over the country. One thing that I think is a real problem, especially for clients that have assets in multiple states, is what we call ancillary probate. So, for instance, I have a cabin up in North Carolina. I'm actually building that into some 10 acres that I have up there. And if I die here in Georgia, then I have to probate my will here in Georgia and then go up to North Carolina and probate my will up there as well. That's called ancillary probate. And so you have to do that in every state that you have assets in. And that can be a real pain because, again, you're dealing with lawyers in multiple states and multiple lawyers in multiple venues. So if we want to avoid probate, if that's an issue, and it's not necessarily an issue for everyone, but I think especially the incapacity thing for me is the big thing that I'd like to avoid. I'd like to avoid that conservatorship. And it's just embarrassing. You're getting doctors and lawyers down there in front of a judge, and it's open to the public, and they're arguing about, whether you're putting your pants on correct. I mean, it's not, I can't imagine anybody would want to go through that. So one of the ways that we avoid that is through the revocable living trust, the RLT. And obviously you all know what that means. Most of you already have one. But all trusts initially have three parties. First, you have the grantor. The grantor is the one that sets up the trust. They're the one that have the assets that they want to protect. They set up the trust, they put the assets in the trust. They also appoint the trustee. So they get to pick the primary trustee, which in a lot of cases is them. They get to pick the successor trustee and then, other successor trustees. So the trustee is the one who controls those assets. And then you have the beneficiary. The beneficiaries are the ones that obviously get to benefit of those assets. They get to use those assets. So if you think about your house, okay, the house was bought and paid for by the grantor, right? And that's you. The trustee is the person who has to pay the taxes on the house. They have to fix the roof when things, go bad. I mean, replace the dishwasher, replace the hot water heater, whatever it may be. That's the trustee's job. Manage things, control things. If the house gets sued, the trustee is the one that handles that. Okay. But then also the beneficiary is the one that gets to live in the house. They're the ones that watch the TV and hang out in the jacuzzi, right? That's the beneficiaries. That's also you. So initially, if you think about it, you're the grantor, you set it up, you paid for everything. You're the trustee, you manage everything, you keep it up, you pay the taxes on it, but you're also the beneficiary. You're the one living there. You're the one using the jacuzzi. You're enjoying things, right? You're watching the big screen. So, so that's how it starts. And as time goes on, it may be when the grantor dies, the trustee now is a secondary trustee that may be a child, a spouse, brother, sister, it doesn't matter. That person steps in. As long as you're alive, you're still the beneficiary. But then when you pass, you've always been the grantor. You're no longer the trustee, you're no longer the beneficiary, but you have successors that you have set up behind you to take over. So if we take a look at just visually how this works, I've got some stuff. I've got a car, I've got a house. It's not a Goldwing, but it looks like a nice, I don't know, 57 Chevy, not sure. I've got a revocable trust. I set it up, I'm the grantor, remember that. I'm the trustee, I manage the things. I'm the beneficiary, I get to drive the car, I get to live in the house. I park my car in my garage in my house. I love my car, I love my house. Okay, so what I've done now is I've transferred the ownership of those items into my revocable living trust. So the Kevin Meaders Revocable Living Trust now owns the house and the car that used to belong to Kevin Meaders. Well, he no longer owns those, okay? But now what if Kevin Meaders goes crazy and has incapacity? I hope that never happens, but I could see with the political system how I might actually go crazy in the next few years, especially with the debt that they keep pumping on the next generations. It's terrible. So if I become incapacitated, I'm not going to go down to the court and I'm not going to sit in front of a judge and a bunch of doctors and lawyers. I have friends that I went to college with that are on my medical committee. Now, this can be anybody that you choose. It could be your doctor, it could be your rabbi, your priest, whatever, whoever you want it to be. I have friends from college. They've known me for a long, long time. We're still very close friends. So they've known me for a greater part of my life, 30 years or more. So they're on my medical committee. Now, what are they empowered to do? Well, they come together basically in our boardroom there, and they say, you know what, Kevin's lost it. This is not the Kevin Meaders that we know and love. He would never do this. He would never do that. So they start signing off, and then they walk away. They've signed off and said, yes, Kevin needs help. He is incapacitated. And then automatically what that does is empowers my successor trustee. Okay, so my medical committee doesn't have any power to manage my assets. All they do is come in and say, yeah, this is the Kevin that we know, and this is not the Kevin that we know. Okay, and in that case, it just empowers the successor trustee. Don't have to go through guardianship, don't have to hire a bunch of lawyers and doctors to go down there and argue. And then, my friends are not going to charge me. They're going to come in and say, yeah, he's gone crazy. And they'll know. Now, later on, I die, of course, and then my successor trustee takes the distribution, makes the distributions, and passes it on out to my beneficiaries that I've also named. It also may be that my son Dylan is not of age, and then I've left it in trust for him, which I almost certainly would. I wouldn't give anybody money until they're 45, 50, maybe 40 at least. We've all been down that road and we've seen it. And these days, if you can make it to 40, 45 on your own without killing yourself, I think you're probably okay. Okay, so one of the things about estate planning is dealing with estate taxes. And estate taxes are federal taxes. There are some states that have them. We'll talk about that in a second. But federal estate taxes are basically taxing the decedent on the right to pass assets to the next generation. So some people get excited and say, well, I'm just going to skip a generation. Well, they've got generation skipping taxes to stop that. And they say, well, I'm just going to give my money away. Well, they have gift taxes to stop that. So, every time somebody comes up with a great idea of a way to get around this, then they pass a law to plug that hole. So for instance, if you give any assets away within the last 3 years, all of those assets come back into your estate for estate tax calculations. That's correct. If you have a life insurance policy and you own it, the death benefit of the estate, of the life insurance policy is included in the estate. So there's a lot of things that you wouldn't have thought are taxable that are taxable for the estate. For instance, life insurance is not taxable to the decedent, to the recipient, because it's life insurance. It's not income tax taxable, but it's estate tax taxable. So back in 2022, last year, the exemption was just a shade over 12 million. And that covered a lot of people, covered most people, covered me. So 2023, we're now up to just about 13 million. And I can tell you that in 24, 25, we don't really know what it's going to be because, well, we don't know what inflation is going to be. Although I can predict that it's probably going to be pretty good. In other words, pretty bad. So in 2026, this all reverts back to the 2017 exemption, which is about 6.5 million. And I can tell you that doing a search on this, you can get conflicting information about what what's going to happen in 2026. So I can't say that's 100% correct, but that's what the IRS website says. Now, in addition to the federal tax, there's also states that have piggybacked on this tax. And these are the states that are part of this. And I know we've got some people from Washington and Oregon State here that are listening. We also have some people from Illinois, and I've got some clients in Washington, D.C., and I got some in Connecticut, and I have some in Maine, and I have some in Maryland. I don't think I have anybody in Vermont. We have some in Massachusetts for sure, New York for sure. No one I can think of in Minnesota, but yeah, I mean, we've got a lot of clients in almost every one of those states. So that's a consideration because that's an additional tax. Now, other states have something called an inheritance tax. Now, this is different from the estate tax because the estate tax is taxing the estate, which is the decedent, which is the person distributing the assets to the next generation. This is a tax on the people receiving the inheritance. Okay, so some of these you would expect, but there you go, Gay. There's Kentucky, Nebraska, Iowa, Kentucky, Pennsylvania, New Jersey. You would expect New Jersey and Maryland to be there. So I've got clients in Maryland and New Jersey, so pay attention there. No clients in Nebraska. I can't think of anybody in Iowa, but I'm surprised that Nebraska and Iowa are on there, quite frankly, and Kentucky. But New Jersey and Maryland, I would certainly expect them. So, you know, you've got to consider, okay, does my state, you know, I know that I have this federal tax, but do I also have this state tax? And do I also have this inheritance tax? So sort of three different things you have to look out for, in addition to, you know, capital gains and IRA income taxes from large IRAs. Now, one of the ways that we can double the exclusion amount, so today it's 12 million, right? We could double that to 24 million. This is only for married couples. Okay. So if, take me for instance, I have a revocable living trust and I have my assets in it. And if I die, then I have this thing called a credit shelter trust, and my assets go into this trust up to the credit limit. So today that's 12 million, and that should do well. That should cover most things. So I've got my assets at my death going into this credit shelter trust. Now, my wife's assets will go into her account, well, a survivor's trust. And that's her money. So she can do what she wants to with that. She can take it, all the income. But, you know, here's my family. There's my wife and my new son, Dylan. He's almost 10 months old. He's almost walking. He's definitely standing. And he's saying lots of things. I don't know what they are, but he's excited. He's very happy. But he doesn't know that he has this credit shelter trust set up for him that's going to provide income and principal as needed. Now, the principal can be pierced for health, income, for health, welfare, maintenance, and support, and education. So any of those things, he could draw down the principal as needed. And then, of course, my wife can get to her own assets as they're needed. If my wife then passes away after the second spouse dies, then my trust pays out to Dylan. Her trust pays out to Dylan. And then that way we were able to double the tax-free amount going down to my beneficiaries. At this point, it's just Dylan. And I have some nieces and nephews that I'd like to take care of too. So hopefully they won't hear or I'm sure they won't watch this, certainly this far, right? All right, so that is how a credit shelter trust can be designed inside of a revocable living trust. Now, just to be fair, it can also be designed inside of a will, and it often is. We call that a testamentary trust. So this trust comes into being essentially when the testator, which is you or me, dies, and then that's what we call a springing trust, and so that's what happens. But we can go ahead and build that into a revocable living trust so that everything is taken care of. And I already have all those possibilities built in. I mean, even the possibility that we don't return from the Amazon cruise, right? There's that possibility. This could be anything. So the advantage of the revocable living trust, I think, are pretty good. I mean, it's the guardianship for me that really gets me, you know, and then I don't have to deal with the courts. I mean, I'm a lawyer. I've been dealing with courts since, 1996. I'm sick of that. Okay. It avoids probate, which is part of the problem. It's probably what we're after, right? Is getting around that. The privacy part, I mean, I don't care about that too much, but I'll take it, right? Especially with all the fraud that's going on these days. Ancillary probate, that's a big one for me because I have this property in North Carolina, and we have some property in Brazil as well, but we'll have to look at a different way to handle that. The thing about the revocable trust, and a lot of people get this confused with the sister, the irrevocable trust. So if you walk into a bank and say have a trust, they're immediately going to think irrevocable trust. Now that becomes a problem because the irrevocable trust has its own tax ID number, right? It's basically a legal entity unto itself. It's like a corporation, it can vote, according to the Supreme Court. So it's got a completely separate entity. It doesn't use your tax ID number, doesn't use your social. It has its own, files a separate tax return. So it's a lot more involved, right? You might want to remind them, no. If you get that look like, oh, no, it's not irrevocable, it's revocable. And we have all kinds of documents and court letters that will say, hey, it's revocable. You use the same tax ID number, same social security number. You don't have to file a separate tax return. Okay, there's not any barriers there. It's not gonna cause a due on sale clause on your mortgage. It shouldn't cause your school taxes to go up in any way. You should get your exemption just like you always did. Those are the things that happen when it's an irrevocable trust. You have those issues. So the revocable trust is easy to change during your lifetime. You can completely revoke it. So that's why it's so flexible. And the way we do it is with schedule. So, there are changes. There's changes to your medical committee. There's changes possibly to your trustees. There may be changes to your beneficiaries. We see that all every week. So it's something that, is very flexible, and just like a will, it's something that you want to check and keep up with. Now, I'm not going to say it's the do all be all because there are disadvantages, right? Like anything, there's pluses and minuses. Usually it's more expensive. If a will costs $3,000, then a trust is probably going to cost $3,000. It's about 2 or 3 times more expensive, depending on where you go. We have a real efficient system here. So Jennifer could tell you more about that. Jennifer@magellanlegal.com. The other disadvantage that sometimes we get complaints about is this funding process. But I got to tell you, funding is essentially where you're taking the assets that you own today and transferring them into the name of your own trust. Just remember, I told you I own this house, right? It's in the name of Kevin Meaders. I have a deed that says Kevin Meaders is transferring this title of this house to the Kevin Meaders Revocable Living Trust, and the trustee must sign to receive it. Well, who's the trustee? Well, that's me. I'm the trustee. So I'm signing away my house from me as Kevin Meaders, the person, the natural person that can die or get killed or run over by a bus, just like that, to the Kevin Meaders Revocable Living Trust that doesn't die, doesn't get sick, right? Doesn't have a stroke, doesn't have a heart attack, doesn't get hit by a bus. And even if it does get hit by a bus, we've got copies. So the trust doesn't die. The trust doesn't get sick, right? It just is like a corporation. Instead of the president taking over, the vice president will then take over. It's instantaneous, just like that. No, so that we've got to get the assets into the trust so the trust can control them. That's what we call funding. So the main thing that we want to fund are non-IRA accounts. Okay, because why? Because IRAs have a beneficiary designation, and you really should handle IRAs via the beneficiary designation. In some cases, we do point the IRAs to the Revocable Living Trust because we have language inside of there that allows us to continue the IRA status as long as we have identifiable beneficiaries that otherwise would qualify. And if you missed something in there, then email me later. Real estate, just like I said, my house, my property up in North Carolina, I definitely want to put, it's already in my revocable living trust. When I bought it, I had it initially put in that way because if something happened to me, I don't want to have to go through ancillary probate because it's the money coming out of my estate. And I want that money to go to my son, Dylan, or Fur Kids or Scottish Rite Hospital or the Masonic Home for Georgia. So these are the things that I care about, and I don't want my money going to the IRS. I don't want my money going to lawyers. I don't want my money going to the court. I want my money going to my children or my family or the charities that I care about. because I know that all of you are too, but I'm a big animal lover, so that's my big charity. TOD, POD. So that doesn't mean you need to change the TOD or the POD. Remember, that's transfer on death for brokerage accounts, payable on death for bank accounts, savings accounts, that type of thing. You may have those want to pay or transfer through the trust. You probably would prefer to have the trust own those things. And here's why. Mainly because the incapacity. The POD and the TOD do nothing really until there's death. When there's a death, they get a death certificate, then the TOD pays out, then the POD pays out. But if you're incapacitated, then it's going to have to fall under the power of attorney for financial power. If you've got that fixed, then you've got that whole plugged, right? So then you're okay. Whether you have it in the trust or have it TOD, POD, or power of attorney, you need to have some way for your successor trustee or your executor, executrix to be able to get to it if they need it for your long-term care needs or hospitalization or healthcare. And then finally, there's beneficiary designations. Remember, I said IRAs, life insurance, annuities, those all have beneficiary designations. They already bypass probate, but they might not have the ability for your financial power of attorney to get in there and do things. So even though you may have the beneficiary designation on your IRA, that's fantastic. You need to make sure that your IRA custodian has a backup POA on files, that for your wife to go in there and do whatever business, whatever withdrawals that she or he may need to make on your behalf in case you're incapacitated. You follow what I'm saying? Good. You wouldn't think that is needed, but we see it all the time. And generally, IRAs are the largest asset that people have, and those are the assets that we need when we're having medical issues that sometimes can run into $10,000, $20,000 a month. That happens. I've seen that happen multiple times with clients. We've seen some go up into the 30s per month, and that's full-blown memory care in like a downtown Seattle area. So and it's very, very nice, but that's a lot of money to spend per month. Okay, so the goals behind all of what we're trying to do, remember here, is the end of life planning, but not just end of life, also that incapacity issue. We can see it. I have people telling me all the time that this person was 30 years old, that person was 40 years old, that had a stroke or died or whatever it may be. We see these athletes falling flat on their face, I don't know, from COVID or the vaccines or something. Our goal is to maintain control upon incapacitation. That's one of my main goals, right? If I'm dead, I don't worry so much. I don't want court intervention in any of that stuff, and I don't want my heirs or I don't want my trustees to have to file records or hire a CPA to do the accounting and all that stuff. Let's just keep it all quiet and private between ourselves. Protecting income, that's important to be able to have that POA person that can get their financial POA. Reduce or avoid taxation. I've been talking about state taxes, but there's other things. There's capital gains taxes. Like a lot of people think, well, I'll just give my property to my children, just transfer it to them. Well, I mean, that works, but then you just handed them a big tax bill because you just gave them your tax basis. There's a better way to do it. You can leave it in a trust, and then they can inherit that, and then they get a step up on the tax basis, and then they can turn around and sell it and pay no capital gains taxes. The other problem are IRAs. Remember, the Secure Act got rid of the stretch IRA. You used to be able to leave someone, your child, not your spouse, but a child or anyone else, you could leave them your IRA, and they could stretch it for their entire lifetime. And that really reduced the required minimum distributions, and it really reduced their taxes. Well, that's gone these days. That no longer exists. So if you inherit a large IRA, you have to start taking it out pretty much right away, but you've got to clean it out within 10 years. Okay, and that's going to hurt people that, like if my father were to die right now and leave me a large IRA, there's no chance of that. But if he were to, then that would dump all that income right on top of me, right in my highest earning years, right? And that's just I'll lose half of it. I will lose half of that money to taxes. And don't think that they weren't thinking that, because they were. Finally, the whole thing here about is just confidence in the future. you know, I don't have to worry because I've got this figured out, or I got that figured out. Sometimes you might have a question mark in the back of your mind. You know, what about this, or what about that scenario? We see that a lot, especially with second marriages, kids from first marriages. You know, they just don't work. They just don't work that well naturally. And so really, if you've got things like that going on, you've got to do some more planning. Because I've seen right now, we have a client that's being sued by her husband's daughter from a first marriage. I mean, why is she suing her? I don't know. She hates her. I mean, it's just that simple, because he left her stuff that, you know, he should have left her. And, but she's suing her for no reason at all. But it's happening. You know, she had to hire an attorney, and she's paying legal fees. So anytime you can have creditor protection, that adds a lot to it as well. So what I'm going to go ahead and do now is sign off, and everybody who wants to jump off, go ahead and say thank you and happy Shamrock Day. And don't forget that St. Kevin is also an Irish saint. And for those of you who want to stick around and ask questions, I'm going to stick around and ask questions. And I hope that all of you are very well, stay healthy, stay happy. Spring is coming up. We've got some allergies going on down here, but that should be okay. And I hope to see you very soon. Okay, thank you very much.